Hey, welcome to our coffee conversation for small business owners and tradies, sharing with you news and views. Today, we impart some important information about tax and tradies and record keeping. Hold on to your hats, everyone. You're in for a treat as we present the happiest, easygoing accountant in Melbourne. Please welcome our host, who is a chartered accountant, certified exit planner, SMSF specialist, Geoff Gottlieb, live from Ormond. Take it away, Geoff.
Thank you and welcome everyone for a quick update on a very important case that's just hit the airways of late, and that's the case of Hudson versus the Commissioner of Tax and the Administrative Appeals Tribunal. Very interesting case because it's about some deductions that were denied. So let's go through the case. Just in case you don't know, I'm Geoff Gartley. Welcome. Let's start off with the facts of the case. Very interesting and very relevant for anyone claiming large deductions. So in this particular case, the Administrative Appeals Tribunal upheld the Commissioner's decision to deny two significant tax deductions claimed by the taxpayer. So these deductions were, first of all, a $14,000 work-related car expense for transporting equipment from his home to work, and a $20,000 depreciation adjustment claim. Uh, Basically, this case primarily focused around the taxpayer challenging the administrative appeals penalties and tax assessments imposed by the Commissioner of Taxation. However, the tribunal found that on these key issues, the following, and it was not good for the taxpayer, let me tell you. First of all, mistakes and rectifications. The taxpayer admitted to making errors in their tax filings and argued that these mistakes should have been identified by the commissioner earlier, and then they wouldn't have had all the penalties imposed and the interest charges. However, the tribunal rightly, and I sort of tend to agree on this place, said that while mistakes had occurred, this did not exempt the taxpayer from the penalties, since the Commissioner's role was not to verify or identify errors immediately upon the initial findings of the filing of the returns. However, these days they do flag large expenses. And there was administration appeal, penalties were imposed for not exercising reasonable care. The taxpayer again contested these on the basis that there was established legal principles that such penalties apply regardless of whether the error was caused by financial or damage to the ATO. So they contested those. And then, of course, there was the general interest charge. The general interest charge was found to be at a standard approximation to the ATO of the unpaid amounts due. So on all cases, he lost that. This particular case serves as a reminder of the importance of maintaining accurate records. Definitely, in this case, obviously, accurate records were claimed for a ute, as we can see behind. And we'll just quickly go over what the commissioner said in relation to this and why it was appropriate that the claim was denied. So, if we think about it, Jason had a claim that car expenses were work-related as he regularly transported bulky equipment from his home to his workplace. The tribunal found in favour of the ATO because using the car for this purpose was a personal choice rather than a requirement by the employer. So obviously the ATO had made inquiries of the large claim, rang up the employer, and the employer said, "Oh no, not necessarily needed." So importantly, the tribunal found the equipment was not necessary for Jason's income-producing activities, as his workplace could provide the required tools. So the legal principle and the factor here is in claiming work-related expenses under the Australian tax law, use of the vehicle must be necessary for work itself. It cannot be for mere convenience. The transporting of equipment between home and work generally doesn't qualify unless it's proven that the equipment is essential and it cannot be stored at or used at the workplace. There's obviously the depreciation claim, and the tribunal found that the depreciation also denied as the use of the car was deemed personal rather than work purposes. So, however, it needs to be established that there's a nexus between income and using the claim. So, the ATA AAT in its decision based the following factors. We had the personal choice, that was Jason's decision to transport bulky equipment and was deemed a choice rather than necessarily imposed by his work. And there was also a lack of evidence. So that was a clear one. Lack of evidence that the equipment was required for Jason's income producing activities. So very careful. Implications for future claims by yourselves, by anyone, and probably the less important Jason has had to learn is ensure you have proper documentation. Claims must be backed by sufficient evidence and necessary expenses directly linked to the income generation activities, and understand the boundaries of work expenses. Transporting equipment, especially between home and work, generally is considered personal use unless there's a compelling evidence that the employer requires it and there are no alternatives, e.g. the equipment cannot be stored on the workplace. Interesting argument in that case, because a lot of my tradies say they don't leave their stuff on the workplace because it gets stolen. So principles there learned, and poor Mr. Hudson has paid the penalty dearly. So good records keeping is definitely essential in Australian tax law, and that's where we can help you and making sure you file your tax returns correctly. My name's Geoff Gartley. We look after small business around Melbourne, interstate, Queensland. Give us a call on 039 597 9966 if we can help you in any way. Other than that, get out there and keep doing what you're doing, and have a great afternoon. Talk to you all soon. Visit our website at www.gartleyadvisory.com.au for further information and other blogs and other videos. Take care, everyone.